Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to walk you through how Connecticut divorce mediation works. So what it is, what the process looks like, and whether it might be a good option for you. Now let's start with the basics, so what mediation actually is. Mediation is a voluntary, confidential process where a neutral mediator helps both spouses reach an agreement on all of the issues required to finalize a divorce. The mediator doesn't make decisions for you, and they don't represent either spouse. Their role is to guide the conversation, explain how Connecticut law works, and help you find solutions that feel fair to both sides. Now, it's also important to understand what mediation is not. It is not like going to court, and it's not about winning. Nobody is testifying, there's no judge. It's really a structured conversation designed to help you create your own agreement without the stress and expense of litigation. So what kind of issues can you actually work through in mediation? Pretty much all of them. In Connecticut, mediation can resolve every issue that needs to be decided in a divorce, including parenting plans and custody, child support, alimony, dividing property, retirement and bank accounts and debts, health insurance and tax provisions, and any other terms you want included in your divorce agreement. If it needs to be part of your divorce, it can be handled in mediation. So let me walk you through what the mediation process actually looks like here in Connecticut. It usually begins with an introductory meeting where the mediator learns about your situation, explains the process, and makes sure mediation is a good fit. This is also where the mediator screens for things like domestic violence or power imbalances, which will make mediation less appropriate. Now, after that initial meeting, the next step is gathering the financial information that you will need to finalize your divorce. Both spouses exchange things like pay stubs, tax returns, bank account statements, retirement information, and mortgage statements. Good agreements depend on complete and accurate information, so it's important to gather all of these documents. Now, once this information is gathered, the parties will move into the actual mediation sessions. So you'll meet for multiple sessions where the mediator will guide you through each issue, explain the legal framework, offer options, and help you work towards an agreement. Some mediators even use caucusing, meaning they may meet with each spouse separately if they feel it would be helpful to moving things forward. Now, eventually, you and your spouse will hopefully reach an agreement on all of the major issues, and the next step is putting everything into writing. So the mediator will draft that document, which is called the separation agreement, and that ultimately becomes the basis for your final divorce orders. Now, after the draft agreement is prepared, many couples choose to have it reviewed by an independent attorney, or they may opt to receive advice from an independent attorney throughout the entire process. This is important because the mediator is neutral and doesn't represent either you or your spouse. Now, once everyone is comfortable with the final document, you will move on to filing the agreement with the court. Usually, the agreement will be approved on the papers, meaning you will not have to go to court to appear in front of a judge. The judge will just sign off on the agreement, and your divorce will be finalized. However, it is possible that you will have to appear for a brief hearing in front of the judge if he or she has any questions about the agreement or doesn't understand any of the provisions. So why do many couples choose mediation instead of going through litigation? There are quite a few advantages. Mediation, if successful, is usually less expensive, it's faster, it's private, and it gives both you and your spouse more control over the outcome. And if you have children, it often leads to a smoother co-parenting relationship. But as I mentioned before, mediation isn't right for everyone. It works well when both spouses want a fair outcome and can communicate even if things are tense, but it may not be the right fit when there are safety issues, coercion, or an unwillingness to share financial information. Another question I get a lot is how long the mediation process takes. Many couples finish in 2 to 4 sessions, although more complex cases can take longer. The schedule can be flexible and you're not stuck waiting for court dates as you are if you're going through the litigation process. Now, if your mediation breaks down and is unsuccessful, either spouse can stop the process at any time. Usually the next step is for each spouse to get their own independent counsel to represent them in court. Now, an unsuccessful mediation doesn't necessarily mean that things will get ugly. It just creates a bit of a barrier between you and your spouse, as your respective attorneys will be negotiating on your behalf instead of you negotiating directly with the help of a mediator. So those are the basics on divorce mediation in Connecticut. As usual, if you have any additional questions, you can contact our office. And if you are looking for help with a mediation or other family law issue here in Connecticut, we would invite you to contact our office as well.